Hi, Greg and Marlene. Ever since Anthropic launched Claude for Legal, a lot of focus has been on whether firms and legal departments should be using that in place of or as well as legal-specific applications like Harvey and Legora. But Anthropic is not the only big player to brush up against the legal market. Microsoft has launched its legal agent, embedded in Word and other 365 applications. OpenAI has reportedly hired someone to help build in legal. Perplexity has launched Computer for Counsel with a host of legal MCP connectors, and now it seems Amazon may also have its sights on our vertical with Amazon Quick for Legal. It was already a tough market to navigate when all you had to worry about were the thousands of legal applications. Now you also need to track what's happening in the broader tech ecosystem. We'll soon be publishing a helpful comparison of the big tech offerings for legal with an examination of where in the legal tech stack they might be useful. Stay tuned for that on our site at legaltechnologyhub.com or follow along on LinkedIn at Legal Tech Hub. It's a pleasure to see all of you. Until next week.
Welcome to The Geek in Review, the podcast focused on innovative and creative ideas in the legal industry. I'm Marlene Gabauer.
And I'm Greg Lambert. And today we are going to be digging into a fascinating and probably somewhat counterintuitive theory that's turning the traditional panic over AI on its head. Instead of asking how many legal jobs that the AI will destroy, we're actually going to explore why AI may actually trigger an unprecedented explosion of legal work, opening up massive markets that were historically priced out.
In hearing what our guests have to say about this and to lead our conversation, we are absolutely thrilled to welcome John Rizner, product manager at Filevine. And joining John is Ryan Anderson, the CEO and co-founder of Filevine. John and Ryan, welcome to The Geek in Review.
Welcome,
Thrilled
guys.
to be here, Greg and Marlene.
All right, John, well, let's start off with you because we wanted to talk about the Jevons paradox, which I know a lot of our listeners have heard before. But let's look at the big macroeconomic picture that you guys have brought to our attention as well. Many pundits out there are predicting that AI will contract the legal industry. But you guys are arguing the exact opposite of that with using the Jevons paradox, and that's the economic theory that the technology makes the resources cheaper and more efficient to produce, and then that way the consumption actually skyrockets. So, you mind just talking a little bit about how the paradox applies to legal work and how how we should be prepared for that?
Yeah, totally. So I'm going to talk about it in connection with a product that I'm working on, a citator a la, Shepherd-style citations within Lois. And when we start off this kind of investigating our tooling, I had a number of conversations with some, old law school classmates of mine that did far better in law school than I did. And when, our, appellate litigators went through the elite clerkship rounds. And I was talking with them, and I'm like, if you have the ability with large language models and with kind of new AI tooling, would you be excited to have to kind of chew through fewer kind of research materials as part of your work? And what was interesting is all of them were like, actually, if I had unlimited time and unlimited resources, I would actually want to find more and read more as opposed to find less and read less. And they're like, yeah, if they could, they would love to just like exhaust, boil the ocean, exhaust every possible resource in kind of reading through opinions and reading through, relevant literature on their case before drafting or writing anything or preparing anything. And so I think that as AI tools, especially in the kind of legal research space, the citator space, as they make finding the relevant literature easier and kind of making available more of the relevant literature kind of an immediate delivery to the user, I think rather than lawyers spending less time doing research, we're going to see lawyers spend more time doing substantive research, with the difference really being instead of legal research, instead of lawyers being like, all right, I've got X amount of time, I found this handful of cases, let's quickly draft this and get this out the door. I think you're going to see far more in-depth and nuanced arguments in legal work product due to the fact that lawyers will have an easier access to greater amounts of research material. And I think as a consequence of that too, you'll probably have better opinions come out of courts because the arguments lawyers are making are going to be more nuanced, reflecting the deeper research. So I hope lawyers like doing research. I hope that's kind of why they went to law school, because in my view of it, I think you're going to see greater and greater research and far higher quality research as opposed to kind of lesser or more shallow research.
Yeah, that was going to be my follow-up question on that. Yeah, Pedro.
Last week, and one of the things she mentioned was, used to we would get these one page surveys or reports, and now we're getting these 40-page surveys. So and it's not necessarily better; it's just more. But I think your argument is that the outcome, the results, the research is actually better rather than just more research. Am I
Yeah.
interpreting that correctly?
Because I mean, at their core, and obviously we all know, as our ethical duties, lawyers should be diving through the cases that they're possibly looking at. And I think as these tools evolve and become more mature and can find more relevant and more kind of on point items for the lawyers to read, they will read the same amount, maybe even read more. But in terms of the conclusions they come to will be stronger because they have that better picture of how the law is at that particular moment. So I think your volume will volume may grow, and in addition to volume growing, I think quality becomes far better in the long run.
Yeah, I think that makes sense because AI kind of allows you to kind of separate the wheat from the chaff, and then you can focus more deeply on the things that you need to focus on and sort of leave the other ones.
Yeah, I'll speak to that for just a moment too, from a kind of a market perspective. 2-3 years ago, there were a lot of predictions around what would happen to engineers, coders. Fileline employs a lot of coders. I think we will end the year with something like 400 to 450 engineers, about half of which are ML engineers, but the other half would be kind of your traditional coders. And there were quite a few predictions that AI would reduce the need for corporations, for tech companies specifically, to have as many engineers, because the theory was that there will be so much code written and it'll be so much easier to be written that you won't need as many engineers. And so you'll see some layoffs and you'll see fewer engineers hired. Well, it's been the case at our company, and I think it has been the case broadly across the industry, that the exact opposite has happened. The engineering market sort of hit a low maybe 2 or 3 years ago and has actually kind of climbed out of that, and more are being hired, not than ever, but certainly more than kind of post-COVID lows. And more companies are bringing on more engineers to do more work. And there's a very sort of logical reason for this. We definitely write 10 times more code today than we did before. It might even be more than 10 times more. It's a lot more code. But for every piece of code that we write, it has to be reviewed, it has to be QA'd, it has to be tested. And as the aperture of the product increases, the surface area for problems increases, but also what else we may touch. The sort of ambition of the product also grows. And so what that has allowed us to do as a company is to build a much richer, broader, more end-to-end product offering that we think is really unique. But I think it's the same for a lot of companies. The analogy really holds true for legal. As John brought up, you're going to have lawyers be able to do research more quickly and sort of find truth for their clients, I think in a much broader way, and be able to zero in and find creative ways to apply the facts of their case to the law. But even consider the lawyer who says, instead of bringing that motion that the client just didn't want us to do because it was going to be expensive, and so I didn't bring the motion to compel the deposition of that witness. We just let it go. We just didn't do it in this case. That happens all the time. If you talk to litigators, they'll say their clients didn't want to pay for the witness number 6 who might have had some interesting information in the case. But boy, now that you can bring that motion to compel and it's much easier to draft and much, much quicker, the opportunity costs change. And so the search for truth becomes sort of superpowered. And of course, litigation in particular is a counterparty affair. So what one side does, the other side is having to respond to, and then maybe bring a counterattack themselves. So, for better or for worse, I think truth will get sought out more quickly. But also, I think lawyers are going to be very busy. And I honestly, I wouldn't want to be a judge in this atmosphere. I think it is really hard for the judiciary at this time.
And I think one other item to bring on in this truth question is that I think the uncovered, it's not like we are looking at a field where all the buried treasure has been dug up. I think one of the things we were looking at early on was research by Paul Hillier and Susan Mart, two legal scholars, and they had done kind of quantitative analysis of, all right, how often do, say, you know, Lexis and West agree or disagree on a particular citation, or how often are they returning kind of the same relevant opinions for a particular citation analysis. And what's really interesting is that the differences between the two could be substantial depending on the opinions looked at. So, if you're a subscriber only to West or a subscriber only to Lexis, you may be missing items that Lexis is returning, but what West isn't, or vice versa. And so where AI tooling makes it cheaper and easier to apply different methodologies to find, so you can have your multiple citators use taking different approaches where you are able to do that at a larger scale. I think then you start to discover more of those opinions that were otherwise hidden because you were stuck with one citator and only uncovering those hidden truths via just one type of methodology.
Ryan, I want to go back to something that you mentioned about using the engineers as a parallel path to some of the things that we're seeing in legal. I was listening, and it was I believe it was Adam Mazzari from Instagram that was talking about how his engineering teams are made up now versus how they were pre AI terms, where he was saying he had like every project had like a baker's dozen of people that were on a project, and that ranged from engineers to project managers to researchers and data scientists. And he says now it's essentially like a team of three. And are you seeing similar things like that on your engineering team? And do you think there's a parallel
It
for
is so.
how lawyers will be doing it?
Yeah, and sorry to interrupt you, but yes, we are definitely seeing a reduction in what a single person can do. And let me give an example. This just happened today, about 2 hours ago. I was going through a new feature with our team. We were thinking through about how to design an experience on our deep retrieval engine. We think we have really world-class retrieval, and we think we can kind of search through more documents than almost any product out there. Well, we literally think we're the best in the world at this. But you might imagine there's some UI constraints. Telling the user where you are when you're searching through millions of pages of documents can be tricky. And there was some back and forth about how to do this, and the team's debating, and there's about 10 people on the call, and we're saying, well, how about this method to tell the user what's going on? Here's some other methods to tell the user what's going on. And about 15 minutes into the conversation, one of the engineers goes, well, I actually just coded it. Does anyone want to see what I just did? And we literally shared a screen, and he showed something, not in a production environment, but on his local machine using real live code, and said, here's how I think we should do it. And it was working. And we could actually play with it right there during the meeting. I can tell you that kind of interaction never happened before. Never.
Yeah.
We have lawyers who say, I was exploring an argument that I didn't think would be a good idea, but I used Lois, and all of a sudden it found a couple cases, and it was a line of case law theory that I didn't think applied to my case, but it does. And so we're going to actually attack the other side in a way that we hadn't realized at all. And when you lower the cost for exploration, for creative exploration, people become much more creative. I've always thought the best lawyers are actually like exceptionally creative. It's funny, lawyers don't think of themselves as creatives. They think of artists and movie stars and musicians as creative people. I think great lawyers are exceptionally creative. And by lowering the cost to kind of go on a creative thread with a legal theory, you enable much more creativity. It's very exciting.
So, Ryan, when we talk about lowering costs to capture a dormant market of middle class clients and small businesses, what specific practice areas or legal needs do you think will see the quickest influx of new work? How does Filevine view this unfolding from a macro strategy perspective?
It is, there's many great things about AI. There's some scary things about AI. But in the legal industry, perhaps the most exciting is we all know that getting a lawyer is actually quite a challenge. My brother, who's our chief product officer, talks about how he needed a lawyer to help with a relatively small real estate dispute. Here's a guy who literally leads product for a pretty significant legal tech company, has a brother who was a lawyer and knows many, many lawyers in his day-to-day job, and he could barely get somebody to answer the phone. It is hard sometimes to find a lawyer, and that's a well-connected guy. If you're somebody who's indigent, working class, maybe you don't grow up with the same kind of privileges or connections, it can be extremely challenging to find good legal representation. And it's pretty awesome that lawyers are going to have much more capacity now. I draw a really kind of quick example. You asked kind of what industries. I think you'll see a lot more in family law. I think you'll see a lot more immigration law. I think you'll see a lot more bankruptcy. And I think underrepresented criminal defendants are going to be in much better shape than they are today. And in fact, a lot of those state public defenders' offices are clients of Filevine. The Innocence Project is a client of Filevine. You're going to be able to have more people who have meritorious claims for wrongful prosecution or for not having a lawyer who kind of didn't do the job they should be doing to win their case or at least get them a lower sentence. Many more of these cases can be taken on. It's incredibly exciting. So I think you'll see it across the board in those areas. And the example I give is if you have a lawyer who has, well, these are lawyers, so we'll say they have 10 hours in their workday, and it now takes 2 hours to draft a will instead of 8 hours. Well, that means how many more people can they serve in a given day? If they could draft one will in 8 hours, or maybe it was 4, and now can do it in 2. Well, you're now serving something like double the number of people during a day. You don't even have to reduce your rates that much. In fact, maybe your rates stay the same. They might even go higher, but you're able to serve more people, and those people wind up paying less because they're taking less of the lawyer's time. So it's kind of a very exciting world we're going to live in. I don't know how that we know exactly how it will all play out, but more legal customers will be served than ever before. It's very exciting.
What do you think about like labor and employment? Would that be one area as well?
Oh, for sure. No,
Mhm.
undoubtedly. I would love to say that this is maybe good news for corporate defendants. It's probably not good news for corporate defendants. So they'll have more tools at their disposal to investigate these claims, and they're often not meritorious. And so, Filevine wants to help those customers, but also, plaintiffs' lawyers who have meritorious claims against corporations also use our products. And so, we really want to help lawyers find the truth. We want to help the justice system find the truth. We are huge believers that the American system of justice not only is the best in the world, but forms the infrastructure for a fair and just capitalist society. We think it's really critical. The lawyer's role in a system of capitalism, because otherwise it's hard to keep business in check. So we're really proud to serve our customers, sort of whatever side of the V that they may be on. But yes, I think you can expect an increase in litigation across the board.
I'll go back to when you were saying it's going to be a difficult time to be a judge right now because I think that's one area that if we don't figure out how they are going to handle this massive influx of new cases, it doesn't matter really how much the efficiency gets on the plaintiff defendant side if there's no if the court system is inaccessible.
I just wonder if they're going to get like AI version of Judge Judy. It's like people will agree that
Are you
like
guys
okay,
working on that, Ryan?
people will
Yeah,
agree to the AI judge and let them
they
decide.
might.
In smaller matters. Yeah,
Yeah, you could see kind of smaller matters, private matters. Obviously, I think
could
there's.
see that for like mediation, sure, like stuff like
Yeah,
that.
I think
Yeah.
so. I think you can envision, small arbitrations that are private where at least they agree to maybe some AI tooling being used. I think that's almost certainly going to happen. It probably should. It probably should happen to a degree. Let me be clear though. Filevine and Lois, which is our AI product, is the core economic engine of this business. We basically only sell Lois and AI products today, which is quite a difference from where we were 3 to 4 years ago. So AI is incredibly important to me. It's incredibly important to this company. We are fully AI pilled on how bullish we are about this industry. Having said all of that, I think the judgment of the lawyer, the judge, the legal professional isn't going away for a really long time. It is one thing to see an AI output as unsophisticated consumer of that information and say, oh, geez, this kind of looks pretty good and pretty persuasive. But I think all of us have seen enough AI results and prompts and frankly slop to go, hold on, this looks like it's right. but it is in fact not right, and sometimes in really critical but perhaps nuanced ways, that kind of legal judgment is going to exist from a long time, for quite some time. And so I think we're a very far ways off from lawyers being replaced, from judges being replaced. But as I'm sure everyone in your audience already realizes, the age of AI and legal is here. It has been here now for a couple of years and is very squarely in our era. We will talk to our grandkids about this transition. It is a very big deal, but we're huge believers in the prime of human judgment when it comes to the law. We believe that lawyers play a really critical role.
And, I think I want to tie back to some research that we did this last year on how LLMs respond to, and we might get into the paper in a little bit in this podcast, but we were looking at how different LLMs or different families of LLMs react to the same kind of law and economics breach of contract issue and how they compare to humans. And it was maybe surprising, maybe unsurprising, was that depending on what model or what family of models you were using, you could see dramatically different results on whether the LLM just was pushing you as the kind of pushing the judge or pushing the practitioner to push for a breach of contract or to keep a promise. So I think there could be even a future in which, you have, if we're talking about our LLM based arbitrators, where folks are fighting over which LLMs or which tech tools to use, because there's that risk of the tool you use could affect what answers you're coming to. And so I think that's another argument why the human attorney needs to remain a core part of the practice, because I think there's a danger, or I don't think we're yet comfortable giving over our judgment to tools that might already have a judgment that we don't even agree with built in within it.
Yeah. And of course,
John,
yeah, go on.
No,
Sorry.
go ahead. Sorry.
No. I mean, look, we all see the hallucination news daily, and it's everywhere. I think lawyers are right to be very concerned about it. I think judges are right to take a really strict view of hallucination, and it's out there all the time. It is an extremely challenging problem. Hopefully we'll get a chance to discuss sort of what we're doing on anti-hallucination. That's an entire team at Filevine, the anti-hallucination team, certainly with respect to case law. But I'll just give you one example. We had a customer put some data through Claude versus Lois. We think Lois is much more precise than Claude. And Claude came back and it had taken some testimony, and it had put in quotations something that a witness had said, literal quotation marks around what a witness had said. And, it turned out that witness hadn't said that, but it was sort of an amalgamation of 3 or 4 things the witness had said. If you looked at each statement the witness had said, you could understand how Claude would have arrived at the conclusion that the witness had said this quote, but the witness had not said that. And any lawyer looking at the quote versus what the witness had actually spoken and verbalized in the deposition, totally different. And so where the legal judgment to know the difference between what is close and what is precise is going to be needed for a long time. So we're not there yet, but AI tools are very important, but they have to be watched over for sure.
Well, I want an anti-hallucination t-shirt. Like anti-hallucination team t-shirt, that's what I want. So John, Greg and I saw your presentation at Texas Trailblazers a few months back, and you noted that AI adoption follows incentives and that trust in AI is ultimately a workflow problem. So since, of course, we're talking about Gen AI, it wouldn't be fair to not have a billable hour question. So if efficiency gains allow lawyers to draft, a complex contract or review a file in, fraction of the time, how do firms need to restructure their incentives so they aren't punishing efficiency under this traditional hourly model? And honestly, I mean, if you have this, that's the secret sauce, because we're all grappling with that.
This is the $1 billion, maybe $1 trillion
so here
question.
you go.
And I think on the one hand, the billable hour has survived a lot of technological change so far and has not disappeared yet. So I think the billable hour has some weight to it that will be hard to remove. I think coming back to our to kind of Ryan's point on the will piece, and as well as our opening point about quality, I think producing a particular piece of work product today takes 8 hours, and we push it down to 2 to get that same exact work product. Well, where there's still runway to improve on that particular document, a better researched argument, a more just ironclad contract, kind of a will that really thinks through all the elements of this particular family situation and gets exactly how the just throwing back to my law school days, the testator, is that the right term? Kind of throw back
Yeah, yeah.
to trusted
That's it.
states.
Yeah.
But I think with that extra time, now the associate or the partner has the ability to provide a better work product, something that really reflects what their particular client needs at same price or less price, or maybe a slightly more price, but with a depth that wasn't even close to what we could achieve today. Then the deep nuance that an associate might not have been required or expected to have today will be a requirement. I think will be a requirement in the very near future and in the long run. So those extra 6 hours will be spent producing that higher level, almost partner level, deep quality that just wasn't accessible or wasn't doable today. So I
Well,
think the billable hour survives for a while, unfortunately or fortunately, depending on what side of the debate you're on. I know I never enjoyed the billable hour, but I think the economics of it still work, especially if you think that volume and quality become a greater and greater focus.
yeah, I've yet to meet someone that loves the billable hour, but yet
When
here
you
we are.
find one, let us know. We want
Yeah.
them on the podcast. It's like,
Yeah.
explain yourself.
Yeah. John, I want to also jump in on your presentation that you did a couple months ago at Texas Trailblazers, because you actually I wasn't sure how well that was going to go over, because it was a
We
pretty
loved it.
in-depth, very deep dive on citation
Yeah.
systems. But I asked a couple of partners at my firm who were in the room there, and they were like, "This was the best part of the whole conference.
I love that.
I love this." And so let's jump into that and more on the lowest legal research product that you guys have as well. You've noted that traditional citators tell you about the case. We kind of talked about that earlier, but lawyers really care about the specific holding that's going on. Do you mind kind of giving us almost like a Reader's Digest version of what you presented there, and talk about kind of these dual pathway retrieval systems under the hood?
Yeah.
I'll turn it over to you.
So it all came kind of our citator approach all came with the idea of, all right, are there workflows in the current legal system that we think we could mimic using ML tooling, LLMs, to come to the same answer, right, that the current legal process works through. And so what we ended up falling into is, on the one hand, citation graphs and your traditional citation approaches does a really good job when we're looking at those cases that directly engage with another, Chevron and Loper Bright, for example, where you have Loper Bright talking to express about Chevron. But there's all those cases that might talk to issues that are around the issue that you really care about, but might not expressly be cited by what is, what the potential treating cases, because it may be only a part of the larger case, or it might be, the treating and your target citation might kind of those, for whatever reason, clerk that didn't include it, a judge that wanted to make a strategic decision, or those linkages might not exist. And so we thought is, all right, can we find a bunch of opinions that might be relevant either on a citation graph or as we came to it, via semantic similarity, kind of the inherent meaning, the kind of inherent meaning of the text as turned into kind of a mathematical representation. Could we find all of the opinions that could exist and could be relevant to the lawyer's issue? And then from that, let's pass that into almost a mock en banc process where we have a bunch of LLMs operating as judges trying to decide, hey, do we care about these opinions? Is this a relevant opinion to the issue we're looking at? Do we think that it conflicts with the issue we're looking at? And from those kind of mass LLM runs, then produce a structured memo for the user saying that, hey, in this universe, we found, these opinions that might cut across your specific chosen issue for these reasons. And what we're really excited about is finding those opinions that are really, that do negatively engage with one another, but that are really hard to find because they're not cleanly on a citation graph. So like the one that I always go back to, I'm going to go look here in Utah. And in Utah, there's this case called Brinkerhoff v. Salt Lake City. And Brinkerhoff v. Salt Lake City looks at the last kind of few paragraphs talk about this old doctrine of governmental immunity. And there's this test where it's like, this question of governmental immunity turns on if the government activity is like proprietary or governmental. And if you pull up Brinkerhoff on some traditional citators, you're not going to see any negative flags on it. And the reason is that the kind of Brinkerhoff has been talked about in a negative way in later down the road Utah opinions. But the problem is this doctrine that Brinkerhoff used in the final few paragraphs was ultimately cut down by the kind of Utah Supreme Court and the Utah legislature. And because we are, one, surfacing the fact that Brinkerhoff has talked about this doctrine, regardless of whether or not there's later cases mention Brinkerhoff, and two, because we were giving it to this LLM panel approach, this kind of voting and memo writing approach, where the LLMs can recognize, oh, wow, this doctrine is being used with Brinkerhoff. Wait a minute, here's Standiford, this later in time case that attacks the doctrine. We think there's a connection there. That's a conflict there. We're able to find these items that are, again, otherwise unfindable on a traditional citation graph. And so that's the thing I'm really excited about, is we're able to find for lawyers these ideas and conflicts that may be relevant to whether or not, other sides have put an opinion. We want to kind of surface to lawyers, hey, there might be other attacks on that particular propositional law that we can help you find that were just undiscoverable before.
Yeah. Oh man, it brought that presentation all back to me. Remember how I geeked out on that.
It's very cool. I don't know, I know this will be posted in transcript form. If there's a way to show some of John's slides, I mean, the slide that shows.
You can give us a link to the slides.
Yeah,
we'll post that up in the show notes. Absolutely.
I mean, I think as you all probably were when you saw the presentation, just the notion that Westlaw and Lexis find different sets of cases. Good night. That's terrifying.
Yeah.
We're just like, yeah, someone's finally saying it out loud. Yeah.
Right. And then, we've just shown that this method actually picks up a lot of cases that in some cases neither of them found. So it's really interesting.
In doing when we were kind of starting to first benchmark our tooling, we've been pulling down those studies by Susan Mart in Colorado about the different cases they were finding, and we were like, oh, I wonder if some of these research was done 8 years ago or 5 years ago. I'm like, oh, I wonder if because of technological change these differences have started to go away. In our current benchmarking, not so much. Still, the dramatic divergence of which citator you choose, you happen to be using, is going to give you a particular answer. And if you're using a different one, you're going to get a different answer. So it's amazing just how we think, just how much opportunity there is to help fill those gaps and find those and, give folks an ability to find things that they otherwise aren't finding right now with their current tooling.
I'll just briefly note, we have such a wealth of case law, a rich history of case law in this country. It's so cool that, most things have been decided. The vast majority of things have been discussed at some point by some court somewhere, which gives such stability to businesses, to human beings, to politicians, to people operating in our country. And it gives, everyone a tremendous amount of confidence when they make decisions, especially business decisions, to sort of understand what the nature of the law is. And yet the citation system that we use was written, and it was the best we had, but in a deterministic code kind of way. Here's a citation, it links to this other citation, which links to this other citation. And that's great. I mean, that's what we had available to us. And it took humans to sort of chain those cases together in sort of logical trees, progenies of different cases. But LLMs are particularly good at saying these words, these phrases are semantically similar. They have similar meaning to this other set of cases over here. And even though there's no hard-coded citation, we find similarity here, and you should take a look at it. It's really fascinating. It's a great use of LLMs.
Because I think about I just think about the discrepancies that you're talking about and how does that impact, and we're going to talk about the hallucinations, but when you're trying to check for hallucinations and for legitimate sites, like, how does this play into that? And how, the courts are coming down on this, so how do people rely on the tools that they have? Or should they?
Yeah, I mean, we think we have a solution. I'll let John talk about
Yeah.
that, but
So, in my view, it doesn't matter. And this is doesn't even matter. It's not even specific to legal research in terms of case law. But there's such an importance of having corpuses of the information you care about available and engineered in a way that it is kind of best presented to the LLM at the right way, at the right time, and in the right process. I think the real question I think lawyers need to be asking their tech providers is, all right, what corpuses are you using? How are you presenting them to your AI technology? And what benchmark, what kind of evidence do you have that your approach is working well? So it doesn't matter if it's you're using AI in your case file, you're trying to find the right document that outlines a scientific expert's findings on something, or a point of a deposition that you really care about, or if it's on the legal research side, a particular opinion or particular citation that you care about. Either way, it's really important that your legal tech has engineering designed to get to the right point in the corpus for the answer you care about. And for us, we've got on our kind of document side, and Ryan was talking about that earlier with our kind of enormous data science groups. They're really focused on our corpus of case file material on the and kind of stopping hallucinations by using what we call knowledge engine to get the right answers surface to the LLM. On the citational side, what we're focused on doing right now is taking open source corpuses of kind of ground decisions. In this case, Court Listener being our big partner in that. And for any time text is produced within Lois in the chat, whenever we see a citation pop up, to have tooling then check, okay, this has been brought up. Does this case exist? And more importantly, does the user have an opportunity to check if the discussed opinion is discussing the issue we care about? Because I think one of the things that we're now seeing judges talk about is, okay, the case you cited exists, but it doesn't,
say that.
The proposition you're trying to support.
Yeah.
And in my mind, and this is what we're building towards, there's almost like 3 levels of evaluation you have to do for any particular piece of case law. On the first level, is this case actually real? Does this citation actually exist somewhere in the corpus? And that's like your very base level, right? Is John V. Ryan in the territory of Guam, was that citation made up? On the second level, you get that second order hallucination. Does that citation actually refer, or that case refer and support the proposition you care about? Sure, the case exists, but are we talking about, I don't know, Roe v. Wade in a contracts dispute? Like what's being cited doesn't support what you care about. And I think the third level is that citation analysis. Okay, the opinion's good. The opinion exists. It supports what you care about. Now, is it good law in the larger, common law analysis? So I think in terms of building, that's how we're trying to think, how we're thinking about it is, are we building towards hitting all 3 of those evaluation levels?
All right, I want to switch gears for a little bit and move away from kind of litigation and more into the transactional area. So, Filevine started with a strong focus, in plaintiffs litigation, but this January you acquired Pinsights, which is a legal drafting and redlining tool, and brought in Sonia and Miriam Salakian into your executive team and rebranding the tool as Lois for Word. And just as a little bit of background for listeners who might not know, Sonia was formerly a legal strategy expert at Ropes and Gray, and Miriam is a former GitHub Meta product engineer. So, congratulations to you. You brought in the dynamic duo. And I have a couple questions here. Like, why is it critical to corporate and transactional expansion to have something inside of Word? And particularly because I think we're seeing now with some of the larger LLMs that they're actually doing a lot of the work inside that environment. And I realize they're doing stuff in Word too, but you do see a lot, particularly when you're working with larger sets, that they're actually doing it within the LLM environment?
Look, it's a great question. I don't think Word is the final surface for all legal drafting, but it is definitely the dominant surface still today. And we're not even talking about AI legal drafting, just legal drafting. The lingua franca of law is still Word, and probably will be for some time. If I said to you, "Hey, here's the red lines to this agreement. Go ahead and open this link with this other document type you've never heard of. Don't worry about it. You're going to have to sign in and make an account to see it." Marlene, you would say, "No, thank you."
Yes.
Yes, hard pass. I need the Word document, please. And, I think pretty much every lawyer feels the same way. They have all learned to use Word. They understand it. They understand how comments work on Word. They understand how red lines work on Word. So getting an entire industry to sort of re-platform may be challenging. Certainly in the short term, probably in the medium term, maybe not in the long term, but re-platform on a different drafting kind of modal it's going to be really hard. So I think we're stuck with Word. I mean, and maybe that's the right way to say it. Maybe not. I mean, Word, everyone uses Word because it is the most fully featured drafting product the world has ever seen. So there's some good things about Word.
Greg likes Word perfect.
I was
So
going to say WordPerfect 4.2 on DOS.
There you go.
I'm
You'd
up
be
for bringing that
surprised.
he's a
back.
big
Up
fan.
until recently, we still got a lot of customers asking us to integrate
Yeah,
with. Yeah.
those reveal codes, man. Still need those.
So I think that's really critical. So first of all, Sona and Marion would be the first to tell you. And by the way, Marlene, you are right. They are the dynamic duo. These are two very sharp women, sisters, of course. First of all, lovely human beings, just a delight to work with, but as smart of folks as I've ever worked with in my career, and really fun to have them on the team. And they're building out, they'll anchor our San Francisco office. And, that was some time ago now, 6 months ago now. So we've actually built quite a large team around them at this point. And that team is solely focused on AI legal drafting. And of course, they use a lot of the work that John has done and others. But they would be the first to tell you that Word is not the only surface that they're going to work on, and they already work on other ways to draft. But yeah, given the gravity that Word has in the industry, I think it's going to be around for a while. There is a benefit to having everything be in Word. Getting the formatting right is almost impossible without Word, depending
Yeah.
on the court. So
The formatting is a tough thing.
it is
Yeah.
very challenging. And look, I understand judges. I fully understand judges' particularity and frustration around hallucinations, but they get equally as frustrated around some of the tiniest formatting issues. I'm a little less like, okay, I mean, does it really matter? If you have the margins are 1.25 instead of 1.1 or something, but I can tell you that it does to them. And it does to them. And if it does to them, it does to the lawyer practicing in their courtroom. So it's really not optional. And Word can reliably produce the best formatted documents for legal in the world. And so we need to be on that surface, and we want to be world class there. And we do think Lowest Forward is world class. We'll put it up against Claude for Legal or Harvey or Legore or any of our other competitors. We think it's the best redlining and drafting tool out there. And, to that end, we should note that not only is Lowest for Word very good at redlining, we think it's the best at redlining, but the ambition is much stronger than that. It's much broader. It is drafting, and drafting long form, sophisticated, complex legal documents grounded in evidentiary citations and case law citations. That is an ambition that I don't think many of our other competitors have gotten to quite yet. Maybe some at the top of the market with us there. And that's the product we're building, and we feel really proud to build it with those two at the helm. They're doing great, and will do great.
Yeah, sounds like they're a great team to work with.
They're awesome. Yeah, I don't know if you've seen them interview before or met them individually, but sharp, lovely, fun, and incredible. I would say like impeccable product taste. We think that their sort of thought processes and intuition around how to build products that lawyers really love and want to work with day in day out is second.
Well, now I'm regretting bringing you two
I was
on.
going
We
to
should
say,
have
now
brought
we have
those
to
two
bring
on.
them
Well, I
on.
can
So
tell you,
I think, were
they would
you
be better.
teeing them up? You are teeing them up. Good. Because I think that would be a fascinating discussion as to why, lawyers like tools.
Yeah.
I don't even know that I don't
I
even know
would-
that they know why they like tools. So I think that would be cool.
I think you're right. Well, we'd love to have Soda and Marion come on the podcast sometime. So
Well, John, I'm gonna jump ahead because I want to do one more geek out with you while we got you here.
Sounds great.
And I want to bring up a working paper that you co-authored called "The AI's Philosophy of Contract," where you use empirically studied how frontier large language models are handling classic concept like efficient breach and remedies. So here's a chance to geek out. So what did this reveal, and what kind of interested you in writing this paper?
Yeah. So we came across a paper that talked about, basically, it was an empirical study of how humans respond to kind of your classic efficient breach scenario of, it is more economical that you breach the contract as opposed to adhere and follow the contract. And humans, interestingly enough, they had certain breach rates, but then if you included a specific remedy in the contract, you could change how humans, kind of in the behavioral economic sets, respond to those efficient breach scenarios. And so we were curious, as LLMs become a place where you go to kind of ask for legal advice, how they might respond to will they follow humans in how they respond to efficient breach, or will they take a more kind of cold law and economics view, or will they take a softer view? And so that was our kind of big question. So what we did is we took at the time, kind of what were all the main frontier LLMs, Anthropic, Google, OpenAI, and we created just large sets of efficient breach scenarios, and would kind of determine, kind of tracked how these LLMs would respond to those scenarios. And the divergence was wide. I mean, you had Google and OpenAI who were more like, all right, it's economical, go ahead and breach. Well, Anthropic was like, we are never breaching, we cannot breach. And, you might have a swing from high 90% breach rates to under 10% breach rates, depending on what model you were choosing. And, the big striking, that was kind of our big takeaways, was that, this is for practitioners, this should be a thing to think about, because what model you're using might determine if you are getting advice of, all right, let's tell the client to do X versus let's tell the client to do Y. And the other kind of big kind of notes that we were finding as well is the LLMs likewise would respond to whether or not you had specific remedies or specific breach remedies within the contract as well, in a way that a human would also respond to those types of kind of hits from the contract. I think the big thing, there's a lot of discussion in the frontier labs in San Francisco about alignment of humanity generally with these tools. I think lawyers need to start thinking about alignment, as in, does this particular LLM align with my particular jurisprudential philosophy, or how I would approach this particular question at a more theoretical, a more philosophical element, that kind of element of judgment. Because if you just hand it over to the LLM, what answer you'll get and what legal advice you might get will determine if you happen to be talking to Anthropic or talking to OpenAI on that particular day. I think a really interesting question will also be, when we ran that empirical data, and the open kind of open source models hadn't yet had their big day in the limelight, it'll be interesting as well to see to what extent open source models become a way which to choose a particular piece of jurisprudence baked into the model that either you prefer, or that a particular court prefers, or a particular judge kind of prefers. I think there's real questions on that as models proliferate, of folks kind of choosing models that might fit their particular jurisprudential, say that 5 times fast.
Yeah,
This
yeah.
is this. Go ahead. Sorry, Greg.
Just made me think whether or not it follows the University of Chicago economics
Yeah.
theory or Berkeley economic theory. So
Yeah.
I guess how it's trained, right?
Yeah,
It's
exactly.
it's super interesting because I just did a client presentation this morning, and they were talking about, okay, even if it's an approved enterprise foundational model, but if people put in, and it's like the clauses are not what they would put in, but that's what's recommended, and that it's just it just sort of it highlights how important it is to have a playbook, or have some sort of template or guidance to use in addition to the model, because you may be doing something wrongs. That's one point. And the other point is I think about more junior people using these tools, like, someone who's got more extensive experience would, look at this and automatically say, "Oh, absolutely not." But
Yeah.
somebody who's more junior and who's actually using this as a learning tool in addition to a drafting tool is sort of really going down the wrong path.
I couldn't agree. I think it's very scary.
Mm.
I think junior attorneys, boy, you almost wonder how much they should be using it. It's very challenging, and you know, we see at the company, some of our employees who are junior at the company or new to the company, they often rely far too heavily on AI analyses and responses from frontier models. And gosh, you wonder, did they even think about these things? So it's a big challenge, and for that very reason, we're huge fans of lawyers and legal judgment. We think it's gonna be around for a while.
All right, guys, we're going to jump to the crystal ball question. So, looking out, into the near to future, what are some challenges or changes that you think we're going to have to be prepared for as we move along in this age of AI?
You will see model proliferation. We're speaking to you on a day that Meta just came out with maybe their first really good model. And I don't think anybody sort of had that on their bingo card. But here they are with a model that looks, at least initially, based on sort of, what the commentary is online, and even some testing done, that it's a pretty good model and pretty good illegal. And so now all of a sudden there's at least a fourth player, probably a fifth. If you say Grok, Gemini, Claude, OpenAI, and now Meta, uh, you're going to see a lot more of these. We internally are using more open source models than ever before. It is now sort of part and parcel of the work we do to fine tune and train open source models. And so, you know, a lot of folks, I think, believed that there was going to be maybe two, maybe three dominant labs, and people are going to mostly build on top of them. That does not look like it's going to be the case. And in fact, we're seeing the open source models be as good or better with a relatively limited fine tuning than even some of what the frontier models can do. So that really changes the economics for everybody. First of all, it means we can use a lot more inference. It's not as costly as before. It also means that there will probably be a lot more folks choosing to kind of, end customers, law firms, I think, choosing to have a stake in helping to build their own models. And we want to be there when customers do that. That's part of the beauty of Lois is law firms can really customize it to them and keep sort of what makes their firm great within Lois. So I think you're going to see a huge proliferation of models, which is going to be different. It's going to be confusing. It's not, I think, the environment a lot of people expected to see even just a year ago. So that's my big crystal ball prediction.
And I think the one piece I would add to that too is I think with the proliferation of models, you'll see just increasingly, and I like to call it like synthetic secondary sources. I think with your proliferation models and folks having their preferred, their preferred work product, and really what they have spent, for some of these firms, decades upon decades tuning and building their particular approach to the law. I think you'll have kind of tooling models emerge where the analysis provided to a particular lawyer is so customized where it is the specific model and specific data source coming together for like the exact, if the firm name is Ryan and John LLP, it is a technological marriage of our exact corpus with our exact preferred models to give our exact answer at a scale that's just not been achievable because those were locked. The knowledge and the style and the preferences were locked in the brains of the partner or maybe the senior associates. So crazy ability to get just ultra custom legal outputs for users.
I think you maybe not even are going far enough. It may not even be at the firm level. It might be the lawyer level, and it might even be the lawyer paired with the client. I mean, you could envision a world in which you say, for this client, we prefer this model. And I could see that very easily being the case. We already orchestrate through multiple models just to give you a certain response to a query. And so it's going to be a world where you see a lot of models. They're going to be used in a lot of different ways, and they're going to become more and more specialized. It's very exciting. Thank you all both so much for the time today.
Yeah.
Yeah,
Oh,
you
thank
got
you.
it. John and Ryan, thank you very much. Appreciate it.
This was great.
Thanks all.
Yeah. And thanks to all of you for listening to the Geek in Review. If you've enjoyed the show, please share it with a colleague. We'd love to hear from you on LinkedIn and Substack.
And real quick, do you guys, if they want to learn more, where's the best place for them to reach out?
Probably just hit me up on Twitter. DM me on Twitter.
Yeah.
Ryan Filevine is my username on Twitter, and you can find me there. I guess X. We call it X now, right? So it's X. Yeah.
And as always, the music you hear is from Jerry David DeSica. Thank you, Jerry, and goodbye, everybody.
Thanks all.
Thanks.